Hello everyone. Appeals from orders, that is the topic for today. We have seen that we can appeal from a decree, but there are some orders which can be appealed from. Not all orders can be appealed from, only those orders which are specified under the Civil Procedure Code can be appealed from. ಆರ್ಡರಿಂದ ಯಾವುದೇ ಆದೇಶದಿಂದ ಅಪೀಲ್ಗೆ ಹೋಗಬೇಕಾದ್ರೆ CPC ನಲ್ಲಿ ಹೇಳಿರೋ ಪದ್ಧತಿನಲ್ಲಿ ಹೇಳಿರೋ ಆರ್ಡರ್ಸ್ ಮಾತ್ರ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಬೇರೆ ಡಿಕ್ರಿನಲ್ಲಿ ನಾವು ಅಪೀಲ್ಗೆ ಹೇಗೆ ನಾವು ಪ್ರೊಸೀಜರ್ ನೋಡಬೇಕು, ಹೇಗೆ ಪ್ರಕ್ರಿಯೆ ನಡೆಯುತ್ತೆ ಅದನ್ನು ನೋಡಿದ್ವಿ. ಈಗ ಆದೇಶದಿಂದ ಯಾವ ಆದೇಶದಿಂದ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು ಅದನ್ನು ಒಂದು ಲಿಸ್ಟ್ ಇದೆ. ಸೊ ಅಕಾರ್ಡಿಂಗ್ ಟು sections 105 to 104 and 105, then order 43, we are going to study some provisions relating to appeals from orders. Here, what is an order we have already seen under the definition clause, that is section 2 subclause 14. ಆರ್ಡರ್ ಅಂದರೆ ಏನು, ಆದೇಶ ಅಂದರೆ ಏನು, ಯಾವುದೇ ಒಂದು ಕೋರ್ಟಿನ ತೀರ್ಮಾನ ಅದು ಡಿಕ್ರಿ ಅಲ್ಲ, ಅಂಥ ತೀರ್ಮಾನ ಅಂದರೆ ಆರ್ಡರ್. An adjudication of a court which does not fall within the meaning of a decree, that is an order. Or we can say that a formal, as it is defined, a formal expression of any decision of a civil court which is not a decree, that is section 2 subclause 14, that is formal expression of any decision, ಯಾವುದೇ ಒಂದು ನಿರ್ಣಯದ ಒಂದು ಎಕ್ಸ್ಪ್ರೆಷನ್, ಅದನ್ನು ಅಭಿವ್ಯಕ್ತಿ, ಕೋರ್ಟಿನ ಸಿವಿಲ್ ಕೋರ್ಟಿನ ಅಭಿವ್ಯಕ್ತಿ, ಇದು ಡಿಕ್ರಿ ಅಲ್ಲದೆ ಇರುವಂಥ ಅಭಿವ್ಯಕ್ತಿ ಅಂದರೆ ಇದು ಆರ್ಡರ್ ಅಂತ ನಾವು ನೋಡಿದ್ವಿ. ಸೊ ವಿಚ್ ಇಸ್ ನಾಟ್ ಎ ಡಿಕ್ರಿ, ಇಟ್ ಈಸ್ ಅನ್ ಆರ್ಡರ್, ಇಟ್ ಈಸ್ ಸಮಥಿಂಗ್ ವಿಚ್ ಹ್ಯಾಸ್ ಅಡ್ಜುಡಿಕೇಟೆಡ್ ದ ಕೇಸ್. ಸೊ ಅದರಲ್ಲಿ ಅಡ್ಜುಡಿಕೇಷನ್ ಆಗಿರಬೇಕು. ಇದನ್ನು ನೋಡುವಾಗ ಈ ಪ್ರಾವಿಷನ್ದು ಸ್ಕೋಪ್ ಏನು, ವ್ಯಾಪ್ತಿ ಏನು ಅಂತಂದರೆ, ಈ ಕೋಡ್ ಪ್ರಕಾರ ಕೆಲವು ಆರ್ಡರ್ಸನ್ನು ಅಪೀಲೇಬಲ್ ಮಾಡಿದೆ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್. It has made certain orders appealable, not all orders. There are several orders which are passed by the court when the case is before it. Okay, so all the orders are not appealable orders. Only those orders which can go in appeal can be addressed in an appeal by the higher courts. Now, which are these orders? We will look into it, because all orders are not appealable. No appeal lies from other orders. Only those orders which have been specified by the code only can be appealed against. Now, which are these appealable orders? Let us look into all these orders. It is a list of orders under section 104 and order 43. The whole list of orders are specified. First of all, appealable order number 1. This is an order under section 35A. 35A we have already discussed, relating to costs. When there is a vexatious claim or defense put forth by the party, then because of a false or vexatious claims, the court can award compensatory costs. ಯಾವುದೇ ಒಂದು ಸುಳ್ಳು ದಾವೆಯನ್ನು ಹಾಕಿ ಅಥವಾ ಸುಳ್ಳು ಪ್ರತಿರಕ್ಷೆನ ಕೊಟ್ಟಾಗ ಒಂದು ಬೇರೆಯವರಿಗೆ, ಬೇರೆ ಪಾರ್ಟಿಗೆ ತೊಂದರೆ ಕೊಡುವಂಥ ದೃಷ್ಟಿಯಿಂದ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಕೋರ್ಟ್ ಗಮನಕ್ಕೆ ಬಂದಾಗ ಅದಕ್ಕೆ ಖರ್ಚು ಕಾಂಪೆನ್ಸೇಟರಿ ಕಾಸ್ಟ್ ಹಾಕ್ಬೋದು, ಅದನ್ನು ಸರಿಪಡಿಸೋಕ್ಕೆ ಕಾಸ್ಟ್ ಹಾಕ್ಬೋದು. ಇಂಥ ಕಾಸ್ಟ್ನ ಸೆಕ್ಷನ್ 35 ಹಾಕಿರ್ತಾರೆ. ಇದ್ರ ಮೇಲೆ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಸೊ ಫಾರ್ ದ ಆರ್ಡರ್ ವಿಚ್ ಹ್ಯಾಸ್ ಬೀನ್ ಅವಾರ್ಡಿಂಗ್ ಕಾಸ್ಟ್, ಅದರಲ್ಲಿ 2 ಗ್ರೌಂಡ್ಸ್ ಇದೆ. ಯು ಕ್ಯಾನ್ ವೆನ್ ಯು ಗೋ ಇನ್ ಅಪೀಲ್, ಯು ಕ್ಯಾನ್ ಆಸ್ಕ್ ಫಾರ್ 2 grounds. One is that this order should not have been made. Secondly, this order for a compensatory cost, that is a higher amount, it should have been a lower amount. ಇಷ್ಟು ಕಾಂಪೆನ್ಸೇಷನ್ ಕೊಡೋದು ಬೇಕಾಗಿರಲಿಲ್ಲ, ಅವ್ರಿಗೆ ಅಷ್ಟು ನಷ್ಟ ಆಗಿಲ್ಲ, ಅದರಿಂದ ಇದು ಕಡಿಮೆ ಮಾಡಿ ಅಂತಲೂ ಕೇಳ್ಬೋದು, ಅಥವಾ ಈ ಆರ್ಡರೇ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ಬೋದು. These are the 2 grounds which can be asked in appeals. Okay, this is the first order, that is under section 35A. Second one, under section 91, we have seen about public nuisance. You can institute a suit. When you are instituting a suit, you ask for the permission of the court, leave of the court. ಒಂದು ಪಬ್ಲಿಕ್ ನ್ಯೂಸೆನ್ಸ್ ಮೇಲೆ ಕೇಸ್ ಹಾಕಬೇಕಾದ್ರೆ, ಆ ಉಪದ್ರವಕ್ಕೋಸ್ಕರ ನಾನು ಒಂದು ದಾವೆ ಹಾಕ್ತಾ ಇದ್ದೀನಿ, ಅದಕ್ಕೆ ಒಂದು ಅನುಮತಿ ಕೊಡಿ ಅಂತ ಕೋರ್ಟ್ಗೆ ನೀವು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದಾಗ ಅದನ್ನು ಕೋರ್ಟ್ ನಿರಾಕರಿಸುತ್ತೆ. ಆ ನಿರಾಕರಣ ಮಾಡಿರುವಂಥ ಆದೇಶ ವಿರುದ್ಧ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಸಿ ದಿಸ್ ಈಸ್ ಅನ್ ಅಪೀಲೇಬಲ್ ಆರ್ಡರ್ ಫಾರ್ a particular purpose. Okay, section 91 allows this has given this particular order under section 91. So under 43 you can go for appeal. Next, appealable order number 3, that is again section 92, where there is a public trust. ಒಂದು ನ್ಯಾಸ ಇದ್ದಾಗ ಅದರಲ್ಲಿ ಬ್ರೀಚ್ ಆಫ್ ಟ್ರಸ್ಟ್ ಅಂತ ಹೇಳಿ ದಾವೆನ ಹೂಡಬಹುದು ಅಂತ ಹೂಡಬೇಕು ಅಂತ ಹೇಳಿ ಅನುಮತಿ ಕೊಟ್ಟಾಗ ಕೋರ್ಟ್ ಅದನ್ನು ನಿರಾಕರಿಸಿದರೆ, ಸಪೋಸ್ ಯು ಫೈಲ್ ಎ ಸೂಟ್, ವಾಂಟ್ ಟು ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಎ ಸೂಟ್ ಫಾರ್ ಎ ಬ್ರೀಚ್ ಆಫ್ ಟ್ರಸ್ಟ್ in case of a public trust, and the court does not give leave to institute the suit. Against that order, an appeal can be preferred. Order number 4, that is section 95. Section 95 has two things. That is, whenever a person is arrested before judgment, or whenever a person property has been attached before judgment, or there is an injunction given. So it is on insufficient grounds that the person has asked. Actually there is no ground for arrest, there is no ground for attachment, or the injunction also could not have been asked for. So because of this particular purpose, if that compensation has been already given, or the order has been given against that, so against that order under section 95 a person can go to the court. So there is if a person files a frivolous case or a vexatious case, and then he asks for the arrest before judgment or attached before judgment and or injunction on insufficient grounds, then that person under section 95 is subject to a fine and also imprisonment that we have seen. Against that order a person can go in appeal. So it is a case where if you file a frivolous case, the court can award fine, that is we have discussed about that, and also imprisonment, either or both. So against that order a appeal lies. Then another the similar, so if a person is arrested and a order directing that person to be arrested or detained in civil prison under section 95, suppose that fine is given and the fine is imposed and he does not pay the fine, then he can be arrested and detained in the civil prison. That is the order which is passed by the court. Against that, unless it is in execution of a decree, if it is in execution of a decree, this does not apply. But without before when it is pending, so in an interim order, if he has been asked to be arrested or detained in civil prison, then under section 95 that order has been passed. Against that order under section 95 an appeal is preferred. Then appealable order number 6, a order returning a plaint to be presented to the proper court. ಒಂದು ಪ್ಲೇಂಟು ಹಾಕಿದಾಗ ಒಂದು ವಾದ ಪತ್ರವನ್ನು ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿದಾಗ ಅದನ್ನು ಪ್ರಾಪರ್ ಸರಿಯಾದ ಕೋರ್ಟ್ ಮುಂದೆ ನೀವು ಅದನ್ನು ಕೊಡಿ ಅಂತ ಹೇಳಿ ಯಾವಾಗ ವಾಪಸ್ ಕೊಡ್ತಾರೆ ಆ ಆರ್ಡರ್ಗೆ ಅಪೀಲ್ ಇದೆ. ಸೊ ಆರ್ಡರ್ 7 ರೂಲ್ 10 ಪ್ರಕಾರ ಆರ್ಡರ್ ಆಗಿರುತ್ತೆ, ಆ ಆರ್ಡರ್ ವಿರುದ್ಧ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ದೇ ಕ್ಯಾನ್ ಗೋ ಫಾರ್ ಎ ಅಪೀಲ್ ಅಗೇನ್ಸ್ಟ್ ದಟ್ ಆರ್ಡರ್. ಸೇಮ್ ವೇ ಆರ್ಡರ್ 9 ರೂಲ್ 9, it provides for rejecting an application that is to set aside the dismissal of a suit for default. Suppose a suit has been dismissed for default and he files a application for setting aside the dismissal of a suit for default, then the court rejects it. That is an order under order 9 rule 9. In such cases where it is appealable case, not in a non-appealable case, in an appealable case, if that application is rejected, then he can go in appeal. ಯಾವುದೇ ಒಂದು ಕೇಸನ್ನು ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಆದರೆ ಅವನು ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ ಕಾರಣಕ್ಕೆ ಡಿಫಾಲ್ಟ್ ಅಂತ ಹೇಳಿ ಡಿಸ್ಮಿಸ್ ಆದಾಗ ಈ ಆದೇಶನ ವಾಪಸ್ ತಗೊಳ್ಳಿ, ಇದನ್ನು ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಅಂತ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಅರ್ಜಿ ಕೊಟ್ಟಾಗ ಆ ಅರ್ಜಿ ಕೋರ್ಟ್ ನಿರಾಕರಿಸುತ್ತೆ ಆರ್ಡರ್ 9 ರೂಲ್ 9ಅಲ್ಲಿ. ಸೊ ಅದ್ರ ಪ್ರಕಾರ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾಗ ನಿರಾಕರಿಸಿದಾಗ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು, ಆ ಆದೇಶ ವಿರುದ್ಧ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ದಿಸ್ ಇಸ್ ಆರ್ಡರ್ appealable order number 7 which can be preferred as an appeal. Again, eighth kind of order, order 9 rule 13. This you know very well, that when it is an ex parte decree has been passed against a person, he applies for setting aside an ex parte decree under order 9 rule 13, and the court rejects that application. So court does not set aside. In such cases, a person can go in appeal under order order 43, that is appeals. ಯಾವುದೇ ಕಾರಣದಲ್ಲಿ ಒಂದು ಏಕಪಕ್ಷೀಯ ಡಿಕ್ರಿ ಆದಾಗ ಆ ಏಕಪಕ್ಷೀಯ ಡಿಕ್ರಿ ವಾಪಸ್ ತಗೊಳ್ಳಿ, ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಅಂತ ಒಂದು ಅರ್ಜಿ ಹಾಕಿದಾಗ ಆ ಅರ್ಜಿ ಕೋರ್ಟ್ ನಿರಾಕರಿಸಿದಾಗ ಆ ಆದೇಶದ ವಿರುದ್ಧವಾಗಿ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ದೆನ್ ಆರ್ಡರ್ 11 ರೂಲ್ 21 ಡಿಸ್ಕವರಿ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬಂದಾಗ, ಯಾವುದೇ ಒಂದು ದಸ್ತಾವೇಜನ್ನು ಡಿಸ್ಕವರಿ ಮಾಡಬೇಕು, ಶೋಧನೆ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಅದನ್ನು ಕೋರ್ಟ್ ಒಂದು ಆದೇಶ ಕೊಟ್ಟಿರುತ್ತೆ. ಆ ಆದೇಶ ಕೊಟ್ಟಿದ ಮೇಲೆ ಆ ಆದೇಶದ ಪ್ರಕಾರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವನು ಸಲ್ಲಿಸಲ್ಲ, ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಲ್ಲ ಕೋರ್ಟ್ಗೆ. ಅದಕ್ಕೋಸ್ಕರ ಅವನ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಮಾಡುತ್ತೆ ಕೋರ್ಟ್, ಅಥವಾ ಅವನ ಪ್ಲೇಂಟಿಫ್ ಇದ್ದರೆ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಮಾಡುತ್ತೆ, ಅಥವಾ ಅವನ ಡಿಫೆಂಡೆಂಟ್ ಇದ್ದರೆ ಅವನ ಪ್ರತಿವಾದ ಅದನ್ನು ಸ್ಟ್ರೈಕ್ಔಟ್ ಮಾಡುತ್ತೆ. ಈ ಆದೇಶ ಏನಿದೆ, ಡಿಸ್ಮಿಸ್ ಮಾಡುವಂಥ ಆದೇಶ ಅಥವಾ ಡಿಫೆನ್ಸ್ ಸ್ಟ್ರೈಕ್ಔಟ್ ಮಾಡುವಂಥ ಆದೇಶ ಏನಿದೆ ಅದರ ವಿರುದ್ಧ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಸೊ ಇಫ್ ಎ ಪರ್ಸನ್ ಈಸ್ ಗಿವೆನ್ ದ ಡೈರೆಕ್ಷನ್ ಬೈ ದ ಕೋರ್ಟ್ to provide the documents for discovery and he does not comply with it, and as a result of that the court strikes out his defense if he is a defendant or dismisses his suit if he is a plaintiff. That order of dismissal or striking out can be appealed against. That is an appealable order. Then order 21 is relating to the order 21 rule 34, that is relating to the execution. We'll come to that later on. See, whenever a endorsement on a negotiable instrument is there and an order which is objecting to the draft of a document, when the court objects to the draft of the document or an endorsement on a negotiable instrument, against that order you can go in appeal. Then order 21 rules 72 to 92, when there is a sale which is ordered in execution, or when a sale is ordered, you apply for setting aside the sale. The person who is affected, he applies to the court for setting aside a sale, or he applies for when he applies for setting aside a sale, refusing to set aside a sale, against that order also an appeal is there. And an order which sets aside a sale, suppose the court allows that application and sets aside the sale, against that order also there is an appeal under order 21. Then 106, rule number 106 of order 21. Here there are if there are some ex parte orders passed in execution proceedings, because if the person doesn't appear before the execution court, then there may be ex parte orders. A person may apply later on to set aside those orders for some sufficient cause, and the court rejects that application. Against that rejection there is an appeal, so he can go in appeal under rule 43, that is under the order 43 as an appeal. An order refusing to set aside the abatement or dismissal of a suit under order 22 rule 9. ಯಾವ ಕಂಡೀಷನಲ್ಲಿ ಸೂಟ್ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಮೃತ್ಯು ಆದರೆ, ಅಥವಾ ಒಬ್ಬರು ಲೇಡಿ ಮ್ಯಾರೇಜ್ ಆದರೆ, ಅಥವಾ ಒಬ್ಬರು ಇನ್ಸಾಲ್ವೆಂಟ್ ಆದರೆ, ದಿವಾಳಿ ಆದರೆ, ಅದನ್ನು ಸೂಟ್ ಯಾವ ರೀತಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೋದು ಮತ್ತು ಅದು ಹೇಗೆ ಕೊನೆಗೊಳಿಸುತ್ತೆ ಅದ್ರ ಬಗ್ಗೆ ನಾವು ನೋಡಿದ್ವಿ. ಇಂಥ ಅಬೇಟ್ಮೆಂಟ್ ಅಥವಾ ಡಿಸ್ಮಿಸಲ್ನ ಅಥವಾ ಈ ಕೊನೆಗೊಳಿಸಿದ್ರನ್ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ವಾಪಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಯಾವಾಗ ಒಂದು ಅರ್ಜಿ ಸಲ್ಲಿಸ್ತೀರಾ, ಆ ಅರ್ಜಿಗೆ ನಿರಾಕರಣೆ ಆಗಿದರೆ, ಅದನ್ನು ನಿರಾಕರಿಸಿದರೆ ಕೋರ್ಟು ಆ ಅರ್ಜಿಯ ಇದರ ವಿರುದ್ಧ, ಆ ಆದೇಶದ ವಿರುದ್ಧ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೋದು. ಸಪೋಸ್ ಎ ಪರ್ಸನ್ applies to set aside the dismissal or abatement of a suit and the order of the court refuses to set aside. So against that order of refusal there is an appeal. Then order 22 rule 10 relating to the assignee, that is for example if a judgment or decree is passed, then an assignee who has been assigned the rights applies to continue the suit. So it applies to the court to give leave to continue a suit, whoever is remaining. So a court, when order 22, of course order 22 is relating to the abatement and dismissal, but if it abates for somebody, the right to sue survives for some other person. So if an assignee asks and that order gives him a leave, or the order refuses to give leave, for both there is an appeal. If the court allows him to continue the suit, against that order also there is an appeal. If an order is refusing to give leave to continue a suit, then also it is appealable. Then order 25, that is security for cause. Here under order 25 rule 2, an order is passed when a person does not furnish security for cause within the time which is fixed for court, and the court dismisses the suit because of that. He files an application before the court to set aside the dismissal of the suit. Suppose the court rejects that application where it is a appealable case. If it rejects that application, then in that case an appeal lies against that particular order. ಯಾವುದೇ ಒಂದು ಸೆಕ್ಯೂರಿಟಿ ಭದ್ರತೆ ಕೊಟ್ಟಿಲ್ಲ ಖರ್ಚಿಗೋಸ್ಕರ ಅಂತ ಹೇಳಿ ಕೋರ್ಟ್ ಕೊಟ್ಟಿರುವಂಥ ಟೈಮ್ಗೆ ಒಂದು ಭದ್ರತೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕೋರ್ಟ್ ಸೂಟನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡುತ್ತೆ, ಆ ದಾವೆಯನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡುತ್ತೆ. ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಆ ಡಿಸ್ಮಿಸಲ್ನ ಸೆಟಸೈಡ್ ಮಾಡಿ ಆ ಡಿಸ್ಮಿಸಲ್ನ ವಾಪಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿ ಒಂದು ಅರ್ಜಿ ಕೊಟ್ಟಾಗ ಆ ಅರ್ಜಿಯನ್ನು ನಿರಾಕರಣೆ ಆಗಿದರೆ ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಆ ಆದೇಶದ ವಿರುದ್ಧ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಆರ್ಡರ್ 33. So when a person asks for permission to sue as an indigent person and the court rejects that application, then he can appeal against that order. ಒಬ್ಬ ವ್ಯಕ್ತಿ ಒಂದು ಇಂಡಿಜೆಂಟ್, ನನ್ನ ಹತ್ರ ದುಡ್ಡಿಲ್ಲ, ಹಣ ಇಲ್ಲ, ನಾನು ಯಾವುದೇ ಕಾರಣಕ್ಕೆ ನನ್ನ ಹತ್ರ ದಾವೆಯನ್ನು ಖರ್ಚು ನಾನು ನೋಡೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾನೆ ಇಂಡಿಜೆಂಟ್ ಪರ್ಸನ್ ಅಂತ ಸೂ ಮಾಡೋಕ್ಕೋಸ್ಕರ. ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಕೋರ್ಟ್ ಅದನ್ನು ಈ ಅಪ್ಲಿಕೇಶನ್ನ ನಿರಾಕರಿಸಿದರೆ ಆ ನಿರಾಕರಣೆ ವಿರುದ್ಧ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ದೆನ್ ಆರ್ಡರ್ 35 ರೂಲ್ 3, ದಟ್ ಈಸ್ ದ 17th one, ದಟ್ ಈಸ್ ಇನ್ ಎನ್ ಇಂಟರ್ಪ್ಲೀಡರ್ ಸೂಟ್. ಅಂತರ್ವಾದ ಇದ್ದಾಗ ಇನ್ ಎನ್ ಇಂಟರ್ಪ್ಲೀಡರ್ ಸೂಟ್ ಫಾರ್ ಕಾಸ್ ಆಫ್ ದ ಪ್ಲೇಂಟಿಫ್, if the order is given and the defendant in the interpleader suit sues the plaintiff in another court, ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾನೆ ಅಂತ ಹೇಳಿ ಕಾಸ್ಟ್ ಆಫ್ ದ ಪ್ಲೇಂಟಿಫ್ ಕೊಟ್ಟಿದ್ರೆ, ಅದನ್ನು ಆರ್ಡರ್ ಮಾಡಿದರೆ ಅದರ ವಿರುದ್ಧ ಒಂದು ಅಪೀಲ್ ಇದೆ. ಅದಲ್ಲದೆ ಆರ್ಡರ್ 38 ಪ್ರಕಾರ ವೇರ್ ದ ಡಿಫೆಂಡೆಂಟ್ ಇನ್ ಇಂಟರ್ಪ್ಲೀಡರ್ ಸೂಟ್ ಸೂಸ್ ದ ಪ್ಲೇಂಟಿಫ್ ಇನ್ ಅನದರ್ ಸೂಟ್, then also there is a appeal. Or for cause and discharge of the plaintiff in an interpleader suit, if the cause and discharge of a plaintiff, if that order is passed that the plaintiff should be discharged or cause should be given, against that order also he can go in appeal. Then if the court gives an order to deposit money or any other property or to furnish security or fresh security for appearance of the defendant, we have discussed all these provisions. So when there is such an order, it is an appealable order. Before judgment, if there is an order for attachment of property under order 38, then against that attachment also, against that order there is a appeal. Then order 39 speaks about the injunction. If you ask for an injunction to the court and it refuses the injunction, or the court grants the injunction. If the court grants an injunction also, you can go in appeal. If the court refuses to grant an injunction, the person who is refused can go in appeal. ಒಂದು ತಡೆ ಆಜ್ಞೆ ಕೇಳಿದಾಗ ಆ ಆಜ್ಞೆಯನ್ನು ನಿರ್ಬಂಧ ಆಜ್ಞೆ ಅಥವಾ ತಡೆ ಆಜ್ಞೆ ಅಂತ ಹೇಳ್ತೀವಿ. ಅದಕ್ಕೆ ಕೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾಗ, ಅದು ಆದೇಶ ಕೊಟ್ಟಾಗ ಅದರ ವಿರುದ್ಧವಾಗಿ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಅಥವಾ ಅದನ್ನು ಕೊಡದೇ ಹೋದಾಗ, ಅದನ್ನು ನಿರಾಕರಣೆ ಮಾಡಿದಾಗ ಅದರ ವಿರುದ್ಧನೂ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ದೆನ್ attachment of property or detention of a person disobeying an order of injunction. ಆ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ನ ನಿರ್ಬಂಧಾಜ್ಞೆ ಕೊಟ್ಟಾಗ ಅದನ್ನು ಪಾಲಿಸಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ, ಆ ಕಾರಣಕ್ಕೋಸ್ಕರ ಅವನ ಪ್ರಾಪರ್ಟಿ ಅಟ್ಯಾಚ್ ಆಗಿದೆ ಅಥವಾ ಆ ವ್ಯಕ್ತಿಯನ್ನು ಜೈಲಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, ಅಂಥ ಆದೇಶದ ವಿರುದ್ಧ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಸಪೋಸ್ ಎ ಪರ್ಸನ್ ಡಸ್ ನಾಟ್ ಒಬೇ ಆ್ಯನ್ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್, then he is liable to be detained in prison or his property is liable to be attached. When the order for attachment is given or order for detention is given, against that order also an appeal lies. Then under order 39 rule 4 again, when an injunction is set aside or an injunction is discharged or an injunction is varied, ಯಾವುದೇ ಒಂದು ನಿರ್ಬಂಧಾಜ್ಞೆನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದ್ದಾರೆ, ತೆಗೆದುಹಾಕಿದ್ದಾರೆ, ಅಥವಾ ಅದನ್ನು ಬದಲಾವಣೆ ಮಾಡಿದ್ದಾರೆ, ಅಥವಾ ಅದನ್ನು ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿದ್ದಾರೆ. ಅಂಥ ಕಾರಣದಲ್ಲಿ ಒಂದು ಆದೇಶ ಬಂದಾಗ ಆ ಆದೇಶ ವಿರುದ್ಧ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಸೊ ಅಂಡರ್ ಆರ್ಡರ್ 39 Rule 10 again, when the injunction is a mandatory injunction, that is, the court orders that person to deposit that thing in the court, or to do something, that is to deposit the money or the thing in the court, or to deliver it to the person who is entitled ಅಂತ ಆರ್ಡರ್ ಕೊಟ್ಟಿರುತ್ತೆ. ಆ ವ್ಯಕ್ತಿ ಕೋರ್ಟಲ್ಲಿ ಆ ಹಣವನ್ನು ಡಿಪಾಸಿಟ್ ಮಾಡಬೇಕು, ಅಥವಾ ಆ ವ್ಯಕ್ತಿ ಯಾರಿಗೆ ಅದನ್ನು ಬರಬೇಕಾಗಿದೆ ಹಣ ಅವ್ರನ್ನ ಕೊಡಬೇಕು, ಅಥವಾ ಆ ವಸ್ತು ಅವ್ರನ್ನ ಡೆಲಿವರ್ ಮಾಡಬೇಕು ಅಂಥ ಆದೇಶ ಇದ್ದಾಗ ಆ ಆದೇಶದ ವಿರುದ್ಧ ಅಪೀಲ ಇದೆ. ದೆನ್ ಆ್ಯನ್ ಆರ್ಡರ್ ಫಾರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ರಿಸೀವರ್. ಸೊ ರಿಸೀವರ್ ಅಪಾಯಿಂಟ್ ಆದಾಗ ಆ ಆರ್ಡರ್ಗೆ ಅಪೀಲ್ ಇದೆ. ಸೊ ಆರ್ಡರ್ 40 Rule 1, there is an appeal. Okay, an order for a taking action against a defaulting receiver. For example, if the receiver defaults in his duties, the court can attach his own property or sell his property also. When that order is passed, there is an appeal against that order, which is passed under Order 40 Rule 4. Then under Order 41, that is an appeal, Rule 19, if an appeal is dismissed for default of appearance by the appellant ಕೋರ್ಟ್ಗೆ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ಅಪೀಲು ಡಿಸ್ಮಿಸ್ ಆಗಿರುತ್ತೆ. ಆ ಡಿಸ್ಮಿಸ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ರಿಸ್ಟೋರ್ ಮಾಡಿ ಮತ್ತೆ ಪುನಃ ತಗೊಳ್ಳಿ ಆ ಅಪೀಲ್ ಅಂತ ಹೇಳಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಾಗ ಅದನ್ನು ನಿರಾಕರಿಸಿದರೆ ಆ ಆದೇಶದ ವಿರುದ್ಧವಾಗಿ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಸೊ ಇಫ್ ಎ ಪರ್ಸನ್ ಡಸ್ ನಾಟ್ appear before the court and his appeal is dismissed for default of appearance, then he can apply for restoring of the appeal. We have discussed about that. Then under Rule 19 of Order 41, suppose the court refuses to restore an appeal, then there is an appeal for that order also. Then under Order 41, Rule 21, suppose this is for the appellant and relating to the respondent, if that respondent has been heard ex parte, that is without calling him, if the hearing has been taken and he applies for a rehearing the appeal and that is refused. So whenever that order is passed refusing to rehear, that order of refusing can be appealed against. ಯಾವುದೇ ಒಂದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಎಕ್ಸ್ ಪಾರ್ಟೆ ಹಿಯರ್ ಮಾಡಿದರೆ ಅಪೀಲು, ಅವನು ಮತ್ತೆ ರೀಹಿಯರ್ ಮಾಡಿ ಅದನ್ನು ಪುನಃ ಕೇಳಿ ಅಂತ ಒಂದು ಅರ್ಜಿ ಕೊಟ್ಟಾಗ ಆ ಅರ್ಜಿಯನ್ನು ನಿರಾಕರಣೆ ಮಾಡಿದಾಗ ಅಂಥ ಆದೇಶದ ವಿರುದ್ಧ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ದೆನ್ ಅನ್ ಆರ್ಡರ್ ಆಫ್ ರಿಮಾಂಡ್ ಇನ್ ಅಪೀಲೇಬಲ್ ಕೇಸಸ್, ಯಾವುದೇ ಒಂದು ಅಪೀಲೇಬಲ್ ಕೇಸ್ ಅಪೀಲ್ ಆಗುವಂಥ ಕೇಸಸ್ಸಲ್ಲಿ ರಿಮಾಂಡ್ ಆರ್ಡರ್ ಆಗಿದ್ದರೆ ರಿಮಾಂಡ್ ಟು ದ ಲೋವರ್ ಕೋರ್ಟ್ ಆಗುತ್ತೆ. ಹೌ ದ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ರಿಮಾಂಡ್ ಇನ್ ಅಪೀಲಲ್ಲಿ ಯಾವುದೇ ಒಂದು ಕಾರಣಕ್ಕೆ ನಾವು ಕಾರಣ ನೋಡಿದ್ವಿ, ಯಾವ ಕಾರಣಕ್ಕೆ ರಿಮಾಂಡ್ಗೆ ಕಳಿಸ್ಬೋದು, ಕೆಳ ಕೋರ್ಟ್ಗೆ ಕಳಿಸ್ಬೋದು. ಸೊ ಆ ಆರ್ಡರ್ ವಿರುದ್ಧವಾಗಿ ರಿಮಾಂಡ್ ಆರ್ಡರ್ ವಿರುದ್ಧವಾಗಿ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ದರ್ ಇಸ್ ಎನ್ ಅಪೀಲ್ ಅಗೇನ್ಸ್ಟ್ ದಟ್ ಆರ್ಡರ್. ದೆನ್ ವೆನ್ ಎ ಪರ್ಸನ್ ಆಸ್ ಫಾರ್ ರಿವ್ಯೂ, ಪುನರ್ವೀಕ್ಷಣೆ ಮಾಡೋಕ್ಕೆ ಪುನಃ ನೋಡಿ ನನ್ನ ಕೇಸನ್ನು ಅಂತ ಹೇಳಿ ಒಂದು ಅರ್ಜಿ ಕೊಟ್ಟಾಗ ಆ ಪುನಃ ನೋಡೋಕ್ಕೆ ಒಂದು ಅರ್ಜಿಯನ್ನು ಇದನ್ನು ಮಾಡಿ ಆ ಅರ್ಜಿಯನ್ನು ಅಲೌ ಮಾಡಿದಾಗ ಅಥವಾ ಅದನ್ನು ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಾಗ ಕೋರ್ಟು ಅದನ್ನು ರಿವ್ಯೂ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿ ಅದಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹಾಕ್ಬೋದು. ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಆದರೂ ಕೂಡ ಗ್ರಾಂಟ್ ಆಗಿದೆ, ಅದು ಅಲೌ ಆಗಿದೆ ಅಂತ ಹೇಳಿದಾಗ ಆ ಆದೇಶದ ವಿರುದ್ಧವಾಗಿ ಕೋರ್ಟ್ಗೆ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ದಿಸ್ ಇಸ್ ಅಂಡರ್ ಆರ್ಡರ್ 47 ವಿಚ್ ಡೀಲ್ಸ್ ವಿತ್ ರಿವ್ಯೂ. ದೆನ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 105 and Order 43 Rule 1A, there are other orders also which can be appealable. That is, this Rule 1A has been introduced as an amendment. See, earlier there was a situation where if the order has been passed and the person doesn't go in appeal, okay, if the person doesn't go in appeal and then it goes on, see there are interim orders in the suit and an order is passed. The person doesn't go in appeal, who is aggrieved, he keeps quiet and the suit is decreed. Later on it is decreed or it is dismissed, whatever the result may be. Suppose it goes in appeal afterwards. In that appeal, whether a person can challenge the order which was given in between the proceedings, ಅಂದರೆ ಆ ಸಮಯದಲ್ಲಿ ಆರ್ಡರ್ ಕೊಟ್ಟಾಗ ಅವನು ಏನೂ ಅಪೀಲ್ಗೆ ಹೋಗಿಲ್ಲ. ಫೈನಲ್ ಡಿಕ್ರಿ ಆದಮೇಲೆ ಅದೇ ಆರ್ಡರ್ನ ಆ ಮಧ್ಯಾವಧಿ ಆರ್ಡರ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೋದಾ ಅಂತ ಪ್ರಶ್ನೆ. ಸೊ ಇದು ರೂಲ್ 1A ಆ ರೈಟನ್ನು ಕೊಡುತ್ತೆ. ಸೊ ಎವ್ರಿ ಆರ್ಡರ್ ವೆದರ್ ಅಪೀಲೇಬಲ್ ಆರ್ ನಾಟ್, ಅದು ಅಪೀಲೇಬಲ್ ಇರ್ಬೋದು. ಇವಾಗ ನಾವು ಏನು ಲಿಸ್ಟ್ ಹೇಳಿದ್ವಿ ಆ ಆರ್ಡರ್ಸಲ್ಲಿ ಎಲ್ಲ ಅಪೀಲೇಬಲ್ ಆರ್ಡರ್ಸ್ ಅಂತ ಏನು 28 ಆರ್ಡರ್ಸ್ ಹೇಳಿದ್ವಿ, ಇವೆಲ್ಲ ಆರ್ಡರ್ಸ್ ಬಿಟ್ಟು ಬೇರೆ ಆರ್ಡರ್ ಇರ್ಬೋದು ಅಥವಾ ಅಪೀಲೇಬಲ್ ಆರ್ಡರೇ ಇರ್ಬೋದು. ಇದರಲ್ಲಿ ಯಾವುದೇ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿರ್ಬೋದು, ಬಟ್ ಅದರಲ್ಲಿ ರಿಮಾಂಡ್ ಇಲ್ಲ, ಎಕ್ಸೆಪ್ಟ್ ಅನ್ ಆರ್ಡರ್ ಆಫ್ ರಿಮಾಂಡ್. ಸೊ ವೆನ್ ದರ್ ಇಸ್ ಅನ್ ಆರ್ಡರ್ ಆಫ್ ರಿಮಾಂಡ್ ದೆರ್ ಆರ್ ಸರ್ಟನ್ ಕಂಡೀಷನ್ಸ್ ವಿಚ್ ಯು ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಡಿಸ್ಕಸ್ಡ್. ಸೊ ವೆದರ್ ಇಟ್ ಈಸ್ ಅಪೀಲೇಬಲ್ ಆರ್ ನಾಟ್ ಕ್ಯಾನ್ ಬಿ ಅಟ್ಯಾಕ್ಡ್ ಇನ್ ಎನ್ ಅಪೀಲ್ ಫ್ರಮ್ ದ ಫೈನಲ್ ಡಿಕ್ರಿ on the grounds that there is an error, defect or irregularity in the order, and such error, defect or irregularity affects the decision of the case. ಫೈನಲ್ ಡಿಕ್ರಿ ಬಂದಾಗ ಮಧ್ಯದಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ರು ಆ ಆರ್ಡರಲ್ಲಿ ಒಂದು ತಪ್ಪಿತ್ತು, ಒಂದು ನ್ಯೂನತೆ ಇತ್ತು ಅಥವಾ ಒಂದು ಇರ್ರೆಗ್ಯುಲಾರಿಟಿ ಇತ್ತು, ಒಂದು ಸಾಮಾನ್ಯವಾಗಿ ಕ್ರಮಬದ್ಧತೆ ಇರಲಿಲ್ಲ ಅದರಲ್ಲಿ. ಸೊ ಅದರಿಂದ ಆ ಕಾರಣದಿಂದ ಈ ಕೇಸಿನ ನಿರ್ಣಯಕ್ಕೆ ಪರಿಣಾಮ ಬೀರಿದೆ ಅಂತ ಹೇಳಿ ಆ ಗ್ರೌಂಡಲ್ಲಿ ಫೈನಲ್ ಡಿಕ್ರಿ ಆದಾಗ ಆ ಮಧ್ಯಾವಧಿ ಆರ್ಡರ್ನ ಚಾಲೆಂಜ್ ಮಾಡಬಹುದು ಅಂತ ರೂಲ್ 1A ಸೇರಿಸಿದ್ದಾರೆ. ಸೊ ಇದು ಸುಮಾರು ಕೇಸಸಲ್ಲಿ ಇದನ್ನು ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದಾರೆ. ಮೊದಲು ನೀವು ಕೊಟ್ಟಾಗ ನೀವು ಸುಮ್ಮನೆ ಇದ್ರಿ, ನೀವು ಅಪೀಲ್ಗೆ ಹೋಗಿಲ್ಲ, ಈಗ ನೀವು ಹೇಗೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. ಸೊ ದೇರ್ ಆರ್ ಸೆವೆರಲ್ ಕೇಸಸ್ ಇನ್ ದಿಸ್ ಮ್ಯಾಟರ್ ದ್ಯಾಟ್ ಒನ್ಸ್ ಎ ಇಂಟರಿಮ್ ಆರ್ ಇಂಟರ್ಲಾಕ್ಯುಟರಿ ಆರ್ಡರ್ ಈಸ್ ಪಾಸ್ಡ್ and the person doesn't go in appeal. Later on, whether he is allowed to challenge it at the time of the appeal from the final decree. So here there is one case, Satyadhan Ghoshal versus Deorjin Devi. That is a very old case, All India Reporter 1960, where the Supreme Court has discussed about the validity of Rule 1A of Order 43. So how that Rule 1A has come to be in the Civil Procedure Code. It has also, the Supreme Court has discussed a Privy Council decision, that is 100 years before whatever was decided by a court in England and also by the Privy Council. Referring to those cases, the court has come to why this order should be there in the Civil Procedure Code, because sometimes what happens when a case is filed and there are a number of applications. On some of the applications the court may give orders. For every order a person may not be, it is not required that he should go to the court in appeal. They are appealable, that's all, or they may not be appealable also. Some orders are not appealable. Whatever is not stated in these preceding sections or preceding paragraphs, they are not appealable orders. So whether it is appealable or not appealable, some order is given in the case and it makes a effect upon the final decision. Then in that case, can the person bring up that question before the court later on. So in this case what has happened is Deorjin Devi, she was a woman who had a minor son. On the behalf of the minor son, she challenged some provisions. What has happened is they had filed a case for eviction against the tenants. They were the landlords, and after filing a case for eviction, there were certain developments, and the person, that is the tenants, here the court passes an order, and after passing the order, he goes in appeal. In that appeal, the order is rescinded. The order of eviction is rescinded. What has happened is, on some grounds, the higher court or the appellate court says that it is not, it cannot be passed according to those laws which were prevailing. See, she had filed a case before a court under a particular law. That was the Tenants Act of Bengal at that time. Then after that there were certain different changes made in the law, and under those laws her right was not there. By that time she had not got the possession. ಅಂದರೆ ಒಂದು ಕಾನೂನು ಇದ್ದಾಗ ಎವಿಕ್ಷನ್ ಆಫ್ ಟೆನೆಂಟ್ಸ್ಗೆ ಕೇಸ್ ಹಾಕಿದಾಗ ನಂತರ ಲಾ ಚೇಂಜ್ ಆಗುತ್ತೆ, ಬೇರೆ ಲಾಸ್ ಬಂದುಬಿಡುತ್ತೆ, ಬೇರೆ ಕಾನೂನುಗಳು, ಬೇರೆ ಶಾಸನಗಳು ಬಂದುಬಿಡುತ್ತೆ. ಅದರಲ್ಲಿ ಇನ್ನೂ ಅವಳಿಗೆ ಅದು ಡಿಕ್ರಿ ಆದರೂ ಕೂಡ ಇನ್ನೂ ಪೊಸೆಷನ್ ತೊಗೊಂಡಿರಲಿಲ್ಲ, ಎಕ್ಸಿಕ್ಯೂಷನಲ್ಲಿ ಇನ್ನೂ ಹೋಗಿರಲ್ಲ, ಎಕ್ಸಿಕ್ಯೂಷನ್ಗೆ ಹೋಗಿರಲಿಲ್ಲ, ಅಮಲ್ಜಾರಿಗೆ ಹೋಗಿರಲಿಲ್ಲ. ಅಂಥ ಸಮಯದಲ್ಲಿ ಬೇರೆ ಕಾನೂನು ಬರುತ್ತೆ. ಸೊ ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಅವನು ಏನು ಮಾಡ್ತಾನೆ, ಒಂದು ಅಪೀಲ್ಗೆ ಹಾಕ್ತಾನೆ. ಆ ಅಪೀಲಲ್ಲಿ ಏನು ಮಾಡುತ್ತೆ, ಈ ಕಾನೂನು ಚೇಂಜ್ ಆಗಿರೋದ್ರಿಂದ ಈಗ ಈ ಮೊದಲು ಕೊಟ್ಟಿರೋ ಡಿಗ್ರಿ ಪಾಸ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿ ಅದನ್ನು ರಿಸೈನ್ ಮಾಡಿಬಿಡ್ತಾರೆ. ಸೊ ಅದನ್ನು ಕೊನೆಗೊಳಿಸ್ತಾರೆ. ಸೊ ಆ ಡಿಗ್ರಿ ಏನಿದೆ ಅದು ನಲ್ ಆ್ಯಂಡ್ ವೈಡ್ ಆಗುತ್ತೆ. ಸೊ ಶಿ ಅಪ್ರೋಚಸ್ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್. Then the appellate court, that is the High Court, says that it cannot be rescinded because even though there is a earlier case or earlier law, under that law she has filed, under that law she has already got a right. ಸೊ ಅದು ರೈಟ್ ಇರೋದ್ರಿಂದ ಈ ಕಾನೂನು ಚೇಂಜ್ ಬದಲಾವಣೆ ಆಗಿರೋದ್ರಿಂದ ಅದನ್ನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿಬಿಟ್ಟು ಅವಳ ಮಾತನ್ನು ಎತ್ತಿಡಿಯುತ್ತೆ ಕೋರ್ಟು. ಈ ಗೋಸ್ ಇನ್ ಅಪೀಲ್. ಸೊ ದ ಅಪೆಲೆಂಟ್ಸ್ ಗೋ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಸೇಯಿಂಗ್ ದಟ್ she has not challenged that rescinding order when it was pending. ಕೋರ್ಟಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇರುವಾಗ ಒಂದು ಆರ್ಡರ್ ಬಂತು, ಆ ಆರ್ಡರ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. ನಾವು ಅಪೀಲ್ಗೆ ಬಂದಾಗ ಅದು ಆ ಆರ್ಡರ್ನ ಚಾಲೆಂಜ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಸಿ ವೆನ್ ಹಿ ಹ್ಯಾಸ್ ಗಾನ್ ಇನ್ ಅಪೀಲ್, ಶಿ ಚಾಲೆಂಜಸ್ ದಟ್ ಆರ್ಡರ್ ಆಫ್ ರಿಸೈಂಡಿಂಗ್, ಸೇಯಿಂಗ್ ದಟ್ ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ಆರ್ಡರ್ ದಿಸ್ ಡಿಸಿಷನ್ ಹ್ಯಾಸ್ ಕಮ್ ಇನ್. ಸೊ ಈ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾಗ ಕ್ವೆಶ್ಚನ್ ಏನಂದರೆ, ಮೊದಲು ನೀವು ಸುಮ್ಮನೆ ಇದ್ದೀರಾ, ಈ ಕೋರ್ಟ್ ಕೇಸ್ ನಡೀತಾ ಇರುವಾಗ ಒಂದು ಆದೇಶ ಬಂತು, ಆವಾಗ ನೀವು ಅಪೀಲ್ಗೆ ಹೋಗಿಲ್ಲ, ನಂತರ ಮತ್ತೆ ಅಪೀಲಲ್ಲಿ ನೀವು ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡೋಕ್ಕಾಗತ್ತಾ? ಫೈನಲ್ ಅಪೀಲ್ ಕೊಡುವಾಗ ಆ ಮಧ್ಯಾವಧಿ ಅಪೀಲನ್ನು ಚಾಲೆಂಜ್ ಮಾಡೋಕ್ಕಾಗತ್ತಾ? ಅಲ್ಲಿ ಕೋರ್ಟ್ ರೆಫರ್ಸ್ ಟು ರೂಲ್ 1A. ಆ್ಯಂಡ್ ದ ಕೋರ್ಟ್ ಸೇಸ್ ದ್ಯಾಟ್ ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪ್ರಾವಿಷನ್ ದೆರ್ ಈಸ್ ಎ just because a person does not, it is not mandatory for him to go to the court. Just because he has not challenged a interlocutory order, can you shut down his rights? So it cannot be, a technical provision cannot take away the substantive rights of a person. ಸೊ ಅವ್ರಿಗೆ ಬಂದಿರುವಂಥ ಹಕ್ಕೇನಿದೆ ಅದನ್ನು ಒಂದು ಟೆಕ್ನಿಕಲ್ ಪ್ರಾಬ್ಲಮಿಂದ, ಒಂದು ಇರ್ರೆಗ್ಯುಲಾರಿಟಿಯಿಂದ ಅದನ್ನು ಚೇಂಜ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ, ಅವರ ರೈಟ್ಸನ್ನು ತೆಗೆದು ಹಾಕೋಕ್ಕಾಗಲ್ಲ. ಶಿ ಹ್ಯಾಸ್ ದ ರೈಟ್. So therefore, she can challenge that appeal. In the final appeal, she can challenge that order. And looking into that, the court has dismissed the appeal of the Satyadan Ghoshal and decided in favor of this respondents in this case. So this is an important case because even if these are all appealable orders, but though they are appealable orders, it is not mandatory for a person to go in appeal. He may go in appeal. If he goes in appeal, immediately he has a tool in his hands to stop the proceedings from going against him. Of course, if there is an order against a person, suppose a person files for an injunction and that injunction is refused, that is an interim order, and that injunction is refused, he continues with the case, or ಆ ಕೇಸಲ್ಲಿ ಮುಂದೆ ಹೋದಾಗ ಅವರು ಸುಮ್ಮನೆ ಆಗಿಬಿಡ್ತಾರೆ, ಅದನ್ನು ಕೇಳಲ್ಲ. That case goes against him. Finally, afterwards, in the final appeal, can he challenge this order, saying that injunction ಆವಾಗ ಗ್ರಾಂಟ್ ಮಾಡಿದರೆ ಈ ಥರ ಆಗ್ತಿರ್ಲಿಲ್ಲ, ಅಥವಾ ಗ್ರಾಂಟ್ ಮಾಡಿಲ್ಲ ಅಂದರೆ ಈ ಥರ ಆಗ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ನಂತರ ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೋದಾ? ಸಿ ಬಿಕಾಸ್ at that time, if there was an error or a defect or irregularity, he has not challenged. That right of challenging is given by the code and it exists. It doesn't amount to acquiescence. That is the interpretation. ಸೊ ಸಾಮಾನ್ಯವಾಗಿ ಈ ಕಾರಣದ ಮೇಲೆ ತುಂಬ ಕೇಸಸ್ ಬರ್ತಾ ಇತ್ತು, ಅದರಿಂದ ರೂಲ್ 1A ಸೇರಿಸಿದ್ದಾರೆ. ರೂಲ್ 1A ವೆರಿ ಸ್ಪೆಸಿಫಿಕಲಿ ಸೇಸ್ ದ್ಯಾಟ್ ಎವ್ರಿ ಆರ್ಡರ್, ವೆದರ್ ಅಪೀಲೇಬಲ್ ಆರ್ ನಾಟ್, ಇಫ್ ಇಟ್ ಈಸ್ ಅಪೀಲೇಬಲ್ ಆರ್ಡರ್ ಆಲ್ಸೋ they can challenge in the final decree. If it is not appealable order also, in the final decree it can be challenged, except an order of remand that cannot be challenged. There is an error, defect or irregularity on that ground, and because of that error, defect or irregularity, the decision of the case has been affected. On that ground, a person can challenge even in the final decree. Okay. Now again, in an appeal against a decree passed in a suit, there are two possibilities. One is, suppose after recording a compromise, there are certain conditions, or after refusing to record a compromise, there is a compromise in a suit, okay, and there is a decree, compromise decree. A person wants to challenge. We have already said that a compromise decree can be challenged only on certain grounds. Now, there are two possibilities, means what? After recording a compromise, the appellant can contest the decree on the ground that the compromise should not have been recorded, or after refusing to record a compromise also, the appellant can challenge that it should have been recorded. ಸೊ ಕಾಂಪ್ರಮೈಸನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳುವಾಗ ಇದನ್ನು ಮಾಡಬಹುದಿತ್ತು ಅಂತ ಹೇಳಿ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಕಾಂಪ್ರಮೈಸ್ನ ರೆಕಾರ್ಡ್ ಅಭಿಲೇಖನೆ ಮಾಡುವಾಗ ಅದನ್ನು ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ಅದನ್ನು ಮಾಡಬೇಕಾಗಿತ್ತು ಅಂತ ಹೋಗ್ಬೋದು, ಅಥವಾ ರೆಕಾರ್ಡ್ ಮಾಡಿದ ಮೇಲೆ ರೆಕಾರ್ಡ್ ಮಾಡಬಾರ್ದಿತ್ತು ಅಂತ ಹೇಳಿ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಈ ಎರಡೂ ಅಪೆಲೆಂಟ್ ಕಂಟೆಸ್ಟ್ ಮಾಡಬಹುದು. ಇದು ಒಂದು ಕೇಸ್ ಇದೆ, ಅನಂತ್ ಕೊಡಬೋಲೆ ವರ್ಸಸ್ ಅಚ್ಯುತ್ ಕೊಡಬೋಲೆ, All India Reporter 1981, where there was a compromise, and in that compromise the person who entered on behalf of the plaintiffs and defendants was an advocate, and the compromise was recorded. Later on, the appellants approached the court to challenge that compromise on the ground that this particular compromise was entered into by our advocate who did not have instructions from us. So therefore, that compromise is not a compromise at all. ಕ್ವೆಶ್ಚನ್ ಏನಂದರೆ, ಕಾಂಪ್ರಮೈಸ್ ಮಾಡುವಾಗ ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಅದನ್ನು ಮಾಡಿದರು, ಅದರಲ್ಲಿ ನಮ್ಮ ಪರ್ಮಿಷನ್ ಇರಲಿಲ್ಲ, ಅಥವಾ ಎಲ್ಲ ಪಾಯಿಂಟ್ಸಲ್ಲಿ ನಾವು ಅದನ್ನು ಹೊಂದ್ಕೊಂಡಿರಲಿಲ್ಲ, ಅಥವಾ ನಾವು ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟಿರಲಿಲ್ಲ, ಅದು ಅಲ್ಲದೆ ಇದು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ. ನಾವು ಸಿ, ವೆನ್ ಎ ಪರ್ಸನ್ ಹೈರ್ಸ್ ಆನ್ ಅಡ್ವೊಕೇಟ್, ಹಿ ಗಿವ್ಸ್ ಹಿಮ್ ಫುಲ್ ಅಥಾರಿಟಿ ಬೈ filing the wakalatnama. There is a rule of law that whenever an advocate speaks before the court, he speaks on behalf of the party. Now, the question is, in this case, whether first of all the compromise can be challenged on that ground, whether it comes within those grounds of challenge which has been stated under Order 23. Okay. Now, under Rule 1A, subclause 2, this has been added that if it is in an appeal and when a compromise is recorded, the appellant can contest the decree saying that the compromise should not have been recorded or it should have been recorded. There is an appeal. So, it is an appealable order. So, whether it can be challenged or not, this is a Bombay High Court decision. In this case, the court says that it can be challenged, and as according to Rule 1A, sub Rule 2, even a compromise can be challenged on this ground. It gives them a right. But then finally, of course, the result comes after the appeal. But whether he can go in appeal or not is the question here. So, the court says that on that ground also, it should not have been recorded. For what grounds? Whether grounds are proper or not will be decided in the appeal. But you cannot say that the appeal itself cannot be filed. So, that is a right of the appellant, and he under this particular Rule 1A, sub Rule 2. And he can approach the court under this. Then, if any interlocutory order has not been challenged, then there is a principle that it would operate as res judicata at all subsequent stages of the suit. No party can challenge during the pendency of the proceedings. Once it becomes res judicata, then it continues as a matter already decided. So, but the correctness of those orders can be challenged in a regular appeal from the final decree. So, in this case, even in the Achyut versus Anant versus Achyut case also, the same thing was challenged, saying that once a compromise has been entered into, it is res judicata. So, when it is res judicata, they cannot question it even in the final decree. So, the question here, why it was dismissed, is that they have a right in regular appeal. What they do is they file a separate suit for it. They file another suit challenging that particular interlocutory order. Compromise ಏನು ಅದನ್ನು ತಗೊಳ್ಳಲ್ಲ ಕೋರ್ಟು, ರೆಕಾರ್ಡ್ ಮಾಡೋಕ್ಕೆ ನಿರಾಕರಿಸುತ್ತೆ, ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಅವರು ಇನ್ನೊಂದು ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ. ಸೊ ದ್ಯಾಟ್ ಬಿಕಮ್ಸ್ ರೆಸ್ ಜುಡಿಕೇಟಾ. ಯು ಕ್ಯಾನಾಟ್ ಫೈಲ್ ಅನದರ್ ಸೂಟ್, ಬಟ್ ಯು ಕ್ಯಾನ್ ಚಾಲೆಂಜ್ ಇಟ್ ಇನ್ ದ ಫೈನಲ್ ಡಿಕ್ರಿ. So, just because an appeal is there, you can challenge any interlocutory order, but you cannot file a separate suit for that purpose. If you file a separate suit, that already has been decided, it has become res judicata, it has been decided among the parties, or it has been concluded among the parties. So it cannot be questioned. But in a regular appeal, it can be challenged. Then what is the limitation for filing an appeal from an order? Same way as we file an appeal under the normal decrees or the judgments, if you file it in any court, it is within 30 days from the date of the decree, is it not? So the same way, from the date of the order, within 30 days you can file a appeal. If it is in the High Court, then 90 days time limitation is there according to Article 116 of the Limitation Act. Within 90 days an appeal can be filed in a High Court from any order which has been decided in the court. Then, which is the forum of appeal? Where you have to file the appeal against the orders. See, the appeal from these orders will be in the same court in which, if the decree was passed, in that decree which court would have taken up the appeal. So where which court has jurisdiction to decide the appeal from that decree, in the same court the appeals from appealable orders also shall lie. So other than the High Court, if the order is made, if it is in the High Court in the exercise of appellate jurisdiction, then the appeal shall lie to the High Court only. So if the order is made by the court other than the High Court in the exercise of appellate jurisdiction, then the appeal shall lie to the High Court. So Order 43 Rule 2 should be looked into, that the provisions applying to first appeals, whatever is stated in Order 41, that shall apply to appeals from orders also. All the provisions relating to first appeals, they will all apply to the appeals from orders in the same manner. That is, as we form a memorandum of appeal, how we file it before the court, whatever the contents of the appeal should be there, all those things apply to order also. Whenever you apply in the court for an appeal from an order, these rules have to be followed. Under section 106, the forum of appeal is decided. So these are the things which we have discussed today. First of all, we said that all orders passed in a suit are not appealable, and only those which are listed in the Civil Procedure Code as appealable orders, they are appealable. That is the point which we discussed today, and we also discussed all the appealable orders in detail. Which are the appealable orders? For a lawyer, this is a very, very important chapter. Normally, for a student, you may think that how do we memorize all these orders? How do we remember all these orders? See, these are 28 orders. It's very easy to remember. See, easy to remember because I have noted the sections, right? Looking into those sections, please remember there are 28 orders. In the order of that, this you can remember those sections. Secondly, if there is a question that what are the appealable orders, you have to first list the appealable orders, and then you have to also mention when the appealable orders are also challengeable in a final decree, or after the final decree also in appeal. That is Rule 1A of Order 43. So that also can be discussed. And then especially for practice, you need to know which order is appealable, because when you are having suits filed in the number of courts and an order is passed in that suit, if you immediately you have on your fingertips that this is an appealable order, you can take an action immediately. You can go in appeal against that order, so that the court does not proceed further on that particular point. Okay. Once you file an appeal, you can ask for a stay in that court, and you can bring a stay, or further proceedings. So these are the tools which are available for us to proceed with our case effectively before the court. That is why this is a very important chapter. An order which is appealable can also be questioned in an appeal to a decree, and if no appeal has been preferred from the order also, you can question that. So this is a second key point which we have discussed today. So these are the important points which you have to remember, okay, and all the orders also. Then summarizing all this, we can say that this list of appealable orders which has been provided in the code separately under a different chapter, it enables the aggrieved party to approach a higher court as soon as the interlocutory order is passed, instead of waiting for the final decree in the suit. But in case he is not able to file also, he can approach the higher court Afterwards, it is not necessary for him to give reasons for that. He can even challenge that order, whether it is appealable or not, in the higher court at the time of the final decree. So, this is the summary of what we have discussed today. So, this is a tool for a practicing lawyer. It is also a very ready reckoner for the students who write the answers for this particular question. So, in the next class, we will be discussing about the last part of this appeals, that is appeals to the Supreme Court. We have seen appeals to the that is the first appeal, that is to the first appellate court. Then we have looked into appeals to the second, that is the second appellate court, that is the High Court. And after that, we will be discussing in what conditions can a person go to appeal in a Supreme Court in the next session. Any questions are there relating to this? Yes. Are there any questions? So, if there are any questions, please post your questions, and also you can post your feedback to this. If you need any other information relating to this, or you have some other thing or some other comment to put forth, it will be welcome, and we will address all the comments. I will try to reply to all your comments and all your questions, which will be for the benefit of a student and also for a person who is practicing. Thank you.